Have you got a claim? Well, a claim costs, and right here is where you start paying. Remember that. What we're talking about, more Rooney and Vardy, because they are now back in court rowing about the costs of their little defamation matter. So just to briefly remind you of that, this is where Rooney, she was worried that somebody was leaking stories about her sort of personal life to the newspapers. So she set up an elaborate trap, because some people have called this Wagatha Christie, although I prefer the Scouse trap, where she slowly reduced the number of people who could see her private messages until there was just one left, which was the Vardy woman. I can't remember their first names. And basically the stories got out there. So she put a thing saying, "Ha-ha! I found it, and I've traced this down, and guess who? It's Rebekah, that's it, Rebekah Vardy." And Rebekah Vardy sued and said, "It's not me, Governor." And this was the one where, phones went missing, falling off ferries, people couldn't access their WhatsApp messages, hard drives were miraculously wiped and all that sort of thing, all very dubious. And in the end, the court said, no, this is actually, she's proved that it's true, it was you, so you lose. Although, interestingly, she didn't only run truth, she ran public interest defence. And to succeed at public interest, you don't actually have to show that the information is true. You just have to show that it was in the public interest to release the information, and also the second part of the test, in the public interest to release the information in the way you did. Now, as we always say, public interest is not the same as of interest to the public. But they said, the court said, fair enough, somebody's been hacking your private, details or finding out, leaking to the press, and that's all very in vogue at the moment. See Prince Harry et al. However, whilst the story was in the public interest, the way you went about releasing the information wasn't, because you didn't give her a chance to reply or respond. So you fail on that. So she succeeded on the bulk of the claim, but failed on that little element of it. And the usual rule is loser pays winner's costs. So although she'd actually substantially won, the judge said, you lost on that bit, so I'm only going to allow you to recover 90% of your costs. Now, when we say loser pays winner's costs, that's generally, in some litigation, like small claims track, you pick up your own bill. In the fast track and the intermediate track, the recoverable rates are capped. But this was what we call a multi-track case, so it's all up for grabs. Now, it's not just necessarily the costs of the actual final litigation. So you've had a preliminary hearing, you've gone for pre-action disclosure, or you've gone for a strikeout or something like that, and you actually lose on that one, but then it goes to trial and you succeed on the trial. It may well be you'll be ordered to pay the other side's costs of the hearing that you lost, even though ultimately you won. And there's all sorts of cost orders. We have what called costs in the case, which is, well, we'll just stick, okay, we've had the preliminary hearing, let's wait till the final hearing and we'll argue about the costs there. Sometimes you get claimant's costs in the case or defendant's costs in the case, which means that the claimant's costs will be assessed at the end, or the defendant's costs will be assessed at the end, but not the other parties. It's like, well, you substantially won, but we'll worry about it at the end, but the other side, have definitely lost. So it's gone off for what we call a detailed assessment. Sometimes, if a hearing lasts less than one day, they'll go for summary assessment. So you put in a schedule of costs, which isn't a full breakdown, but it says things like, how long you spent on witness statements, how long you spent on the pleadings, how long you spent talking to the other side, how long you spent talking to your own client, how long you spent actually at the hearing. Oh, there's a dog. Don't get distracted by dogs. Don't get distracted. I know you all like to see dogs. There's a dog. Right. Where were we? Something about costs and law and things like that. Summary assessment. Summary assessment is very rough and ready. The judge will just look at the stuff and say, okay, your hourly rates look about right. You possibly could have spent a bit less time doing those statements. The hearing fee. I mean, generally speaking, they nearly always allow barristers' fees, which is something I'm very in favour of. But, they might knock you down a bit. And they say, oh, more dogs. Oh, this is great. Stop getting distracted. That's why I came here, because it's a nice dog-friendly place. But yeah, sometimes they will just, like, you know, they admit that it's a very rough and ready calculation, and it's not plucking a figure out of the air, but it, you know, by definition, it's not detailed, because that's what detailed assessment is. So what's detailed assessment? Detailed assessment is where you have actually a full hearing. Sometimes these hearings can last longer than the original trial, and you go through every single item, every line by line, every 6 minutes people have spent doing things, because that's usually how solicitors bill. They have 10 units per hour, 10 6-minute units per hour. They'll be like, I spent 3 units writing this email, I spent 150 units drafting all this material, you know, all that sort of thing. What's the test? Well, the test on a standard basis, because there are 2 ways you can get costs, on a standard basis or an indemnity basis. On a standard basis, the receiving party must show that anything they're claiming, it was a cost that was necessarily and reasonably incurred, and that the overall costs are proportional to the litigation. So it's for the person getting the money to actually prove that it's a legit claim. You'd also, however, get costs on an indemnity basis. Indemnity basis is used usually to punish a party for either being unreasonable in the litigation, or, for instance, failing to beat a Part 36 offer. An automatic consequence, if you reject a Part 36 offer, you know, somebody says, Part 36 offer, I'll give you £100,000, and I agree to pay your costs on a standard basis. If the other side rejects that and it goes to trial and they don't beat that offer, in other words, they don't get more than they were offered, then they do have to pay the other side's costs even though they won, and they pay them on an indemnity basis. Now, with an indemnity basis, the costs still need to be reasonably and necessarily incurred. However, it's for the paying party to show that they weren't. The starting point is, yeah, everything the other side claim is legit. It's for you to argue it isn't. And also there's no element of proportionality there. So even if it's ridiculously over the top, if you can show it was reasonably necessarily incurred. Sometimes it's a bit unfair, though, this necessarily incurred, because we've had cases where people have instructed experts and then the experts have actually agreed. Both sides' experts have agreed, so they haven't been called to trial. And the court said, well, the expert wasn't necessary because we didn't need them, so you're not recovering your expert's costs. I mean, that was one decision I wasn't quite sure of, but that's what you're up against. We apply something called, we used to call it the 7 pillars of wisdom, although now there's 8 of them. And that's things like, what's this sort of complexity of the litigation? How important is it to the parties? Because, like I say, you know, £1 million claim for a multi-billion dollar company is probably less important than a £1,000 claim for a poor person. So, you know, they will take that into account when they're assessing the proportionality. How much work was entailed? What was the conduct of the parties during the litigation? What were the attempts to sort this out by ADR or mediation? Were there any reasonable offers there? How, you know, senior did you need to instruct in terms of the lawyers? You know, how expert did they need to be? All that sort of thing. And the 8th one is now, how close are you to your costs budget? Because multi-track litigation where it's sort of high value claims, you now submit what we call cost budgets right at the start. You have a costs and case management hearing. So you go in front of a special type of judge, a high court judge called a master. And you basically, it's just a big spreadsheet. I've actually done a video on how you do all this. And the spreadsheet predicts all the costs that might be incurred, and you put all the contingencies in there. If we go for a strikeout, it'll be this. If the other side serve this, then we'll need to do this. But you predict, you know, how many witnesses you'll be calling, so how long it will take to do witness statements, how long it will take to do disclosure. And you both go along, you swap those before the hearing, so either side can object to them, because they might say, well, the hourly rate being charged by the person doing that work is too high. That could be done by somebody more junior. There is a bit of a tendency, though, for people to agree cost budgets because they don't want to paint themselves in a corner. Because you always start off assuming you're going to win, so you want to maximise the recoverable costs. So parties quite often will just go, yeah, that's fine, yeah, that's fine. I mean, judges now have actually decried that a little bit and said, oh, you stop agreeing ridiculous cost budgets just to protect your own position. But a lot of the time, the master will just sign off of them if they're in the right ballpark. And generally speaking, if at the end of it you come within 10% of your cost budget, then that goes a lot in your favour in recovering your costs, because it's like, well, the other side had the chance to object to this right at the start, so it's too late to come back now. Unless, for instance, there was significantly less work involved, it had settled early, or the trial had gone short, or something like that. Then you can say, well, the cost budget shouldn't apply because that was based on a premise that didn't actually come true. Also, you can go back and apply to increase your cost budget. You might say, this has got a lot more complicated now. We were suing one person, they've done what we call a Part 20 thing where they add another defendant. Say for instance you're suing me, and I say it's not my fault, it was that other guy's fault, you should sue him. So, well, we're not suing him, we're suing you. I can go, right, well, I'll join him as a defendant then. And then it's interesting because if, say for instance, you do actually find against that other guy and not me, who pays my costs? Is it the losing claimant, because they sued me and they lost, or is it the losing defendant? So these are all the sorts of issues that people look at. In this particular case, though, they've put in a bill of £1,800,300 odd and change. And some of the arguments are, first of all, it's all over the place. They haven't itemised this properly, because you send this off to what are called cost draftsmen, and it is cost draftsmen, even though a lot of them are women, and they are experts in just how to present the case and how to itemise it and how to argue that everything is justified. But they said the bills are a real mess. They're claiming at least £120,000 for something they can't claim for. And also just some of the expenses are just ridiculous, and they shouldn't be allowed to claim them because they've claimed for stopping in the Nobu Hotel and having all their meetings there. Now the counter argument is, well, in the grand scheme of things that was more efficient, because by all staying in the same hotel and all we could go down and have breakfast meetings and evening meetings and react to how things were going through the litigation, and that just made things far more efficient and far more cost effective. So it'll be interesting to see what happens here. But it just goes to show, so much of this is all about costs, because Vardy's not only had to pay her own legal bill, which I gather was in the same ballpark. I mean, that was about $1.5 million. She may well be on the hook to pay all Rooney's costs. My prediction is probably pick about $1.5 million. I mean, you do sometimes point to each other's cost budgets where you will say, well, they're arguing now and say we've charged too much, but look at what they were claiming if they'd won. I did one a while ago. I had a hearing which we succeeded, and the other side I'd put in my bill, which I thought was reasonably reasonable, and the other side's bill was nearly twice as much. So when I stood up and said, well, in all fairness, they can't really argue when you look at how big their bill is. And their counsel stood up and said, yeah, but our bill was ridiculous. And it's like, oh, you can't say that. The judge just laughed. It's like, well, that was very honest. And yes, their bill was ridiculous. Yours isn't quite as ridiculous, but I am going to knock you back. So I think I recovered about 60%. That's the sort of figure you will recover, actually, 60 or 70%. So remember that if you're engaging in litigation, even if you win, you might be 30, 40% out of pocket. And your lawyer, unless they write that off, they're going to come for the shortfall. And technically we can't write that off, because another thing with costs is we have what we call the indemnity principle. That is, you can only recover costs from the other side that you would have been liable for. And an interesting thing there is the other side can say, we want to see all your client care letters and the terms and conditions. And if we can find a loophole that shows you wouldn't have had to pay something, we don't have to pay it either. And people have lost out because they've done CFAs, conditional fee arrangements, no win, no cost sort of thing, and they've not abided by the rules because they're very technical. They've not sent the right letter, or they've not done the oral explanation, and they said, well, they wouldn't have had to pay their own solicitor because they could have got off the hook because of the contract's not quite right, so we shouldn't have to pay it either. I'd be interested to see, that does occur a lot. I mean, I think in this case, nobody's disputing that, all the client care letters were done correctly. They're just disputing whether or not these costs were all reasonably and necessarily incurred. I'll let you know when I find out. But like I say, my prediction is, my Mystic Al thing, I think they'll probably get about $1.5 million. So there you go. As always, hope you found that vaguely useful, vaguely interesting, vaguely accurate. Where am I today? I'm just actually at the bottom bit of the Truro River, because I film up quite a lot of Tresillian, which is the head of the river, and this is the other end of it. I don't know if you can see in the distance there, I'll just come over, because that is Truro Cathedral. It's all a bit mud flatty here today, and I was just basically, I'm not really bothered about standing out in the rain, but the camera doesn't really like it. But there you go. So yeah, this is Truro. When Truro used to be a port, they would bring all the massive ships up here, but now, as you can see, that it's all silted up and that tiny channel, you can barely get up here on a lilo. And that actually used to be over there. That's the old railway terminal. There was a railway line that went up to meet the main line. Now it's just a cycle path and where people like me walk and occasionally bump into badgers.